project my screen. Do we have questions? Anyone with a question from the last class or something that came about when you are reading? We can address it quickly. Isaac?
Yes, how are you? Now, we talked about this presumption of... you can hear me?
I can hear you now.
Okay. So we talked about a creditor to the estate, and we talked about the presumption or the doctrine of satisfaction. You can hear me?
I can hear you very well.
Yes. Now, reading schedule, the first schedule, section 64, it only talks about where the debtor had bequeathed a gift to his creditor equal or greater than the debt. What if the gift was less than the debt? What happens?
Now, the doctrine is the doctrine of presumption of satisfaction. Okay? Presumption of satisfaction. So it means there must be satisfaction. There must be satisfaction. Okay? There must be satisfaction. So it can only be satisfied if the gift was equal or greater than the debt that was there. Somebody's having their phone or their device on.
Sorry, that's mine. Sorry.
All right. So I'm saying for there to be satisfaction, for us to say that the debt is satisfied, then it means the debtor or the testator must have left you something that is equal to the debt that they owed you, or something that was more than what they owed you. So that if I owed you, Isaac, 10,000, for us to be a presumption of satisfaction, then it must be whatever I'm leaving for you in the will must be at least 10,000, so that we can claim that that debt has been satisfied. However, if whatever I left you is below or is less than the 10,000 that I owed you, then we don't assume that is presumption. We don't assume that it has been satisfied, or we can't say it has been satisfied because what you've gotten is not equal to what you owed or the testator owed you. So in that instance, we'll only do a set off. We'll do a set off, and then the administrator will pay the remaining from the estate. But we can only presume the satisfaction. Remember, the key word is, there are two things there: presumption of satisfaction. So there must be satisfaction on the first end. So it means whatever was left for you, for it to be presumed as satisfying the debt, it must be equal to the debt that was left or more than. Okay. Now, in that instance, we shall assume that that debt has been satisfied. But if whatever was left for you was less than what the debt was, then we only do a set off. The gift is set off against your debt, and then the testator's executor or the administrator will proceed and pay the balance from the estate of the deceased person. Naelewana?
Okay, I understand.
Thank you very much. Thank you very much. Joan? Joan?
Good evening. So I have a question. The farmhouse that we were talking about in, I think it was commercial litigation the other day, can you give that as a donatio mortis causa? Because it is movable.
What did we say?
The farmhouse can be moved from place to place.
Did we say what did we say in terms of immovable or movable?
Because we stated that a person gives movable properties but cannot be land or buildings.
That's what I'm asking. Like, did we say a farmhouse is movable or immovable? What did we say?
It is movable.
And what did we say about mortis causa?
You cannot give lands or buildings.
What can you give?
Other movable properties.
What do you mean other movable properties?
Apart from now land or buildings.
Is land movable?
No. But now a farmhouse, it is movable.
What is your question? That is, you're getting it confused.
So because now a farmhouse is a building. Yes, so
Wait, stop playing. What did we say about the farmhouse? I don't know
it can
whether
be
you're getting.
yes. You
What
can
did we
move.
say about the farmhouse?
A farmhouse can move from place to place, so it is a movable property.
And what did we say about donatio?
You cannot give lands or buildings.
What did we say about donatio?
That a person can give any movable properties except now from lands or buildings.
Is land movable?
And no, it is not.
When you say you can give movable property except from land, do you know, are you getting the statement you're saying?
Yes, land cannot pass through donatio.
So what can pass through donatio?
Any other movable property except
Is
land.
Is land movable?
No, it is not.
Why you kama tunaelewana ama ni kizungu ni ngumu? What can pass through donatio? Let's start there.
Any movable property except land or buildings.
Is land movable?
No, it is not.
Why are you including it in the list? When you say all movable properties except land, it means land is also movable, but you can only give other movable properties except land. Are you getting what I'm saying?
Yes, I understand.
So what is the point? What can go under what can you give under donatio mortis causa?
All movable properties.
All movable properties. Is a farmhouse movable?
Yes, it is.
So what is your question?
Because there is this point that we wrote, a person gives movable properties. And I wrote that it cannot be land or buildings. And now I was thinking, because now a farmhouse is a building and it can be included among the movable properties, so we should exempt it.
Is a farmhouse movable?
Yeah, it is.
It is movable.
Yes.
So if it is movable, what is the question? I'm not getting your question. Ask the question so that I can answer it quickly.
The question is, we said that you can only give movable properties under donatio mortis causa, and then we indicated that you cannot land or buildings.
Just stop there. Is a farmhouse movable?
Yes, it is.
Then what is your question? What is the question? Jesus, what is the question?
Now I understand, because I remember you also said about buildings being fixtures.
But a farmhouse is not a building. It's not a building, is it? A farmhouse is not a building. It's not a fixture.
Yes.
I don't know. Honestly, I'm still not understanding your question, though. I want to be honest with you. I'm not understanding your question.
That is where I was confused, but now I think
Confusing about what? You already said yourself that a farmhouse is movable. Under donation, we can give movable properties. What is confusing about that?
I was considering now a farmhouse to be a building.
Even if it was a building, even if it was land, and we have said it is movable. What is the question? Is movable, movable, movable? Is it movable? Is it a
Yes.
property? Yes, it is movable. Yes. Can we give it under donation?
Yes, it can because it is movable.
Exactly. That is the point. That is exactly what I wanted you to understand. Michael. Thank you, Joy.
I think I have a question from what you've just been discussing. The concept of movable and immovable property. I thought donatio motis causa simply provides that as long as the deceased person had the intention of transferring the property will transfer to the person whom he intended to, regardless of whether the transfer was actually done. Doesn't that actually apply to all property, whether movable or removable? Kindly clarify on that.
Hiyo umesoma wapi? Which act did you read that from?
I think both in
Stop
common law.
thinking. What do you mean common knowledge? There's nothing like common knowledge.
Not
Where
common
did you read
knowledge.
that?
Common law, and also I think Section 35 of the Law of Succession Act.
Section 35 talks about instances where the deceased person left a wife and a child.
I will look at the particular section, but I just needed clarification on that.
All right, let me project the act for you right now. Guys, we need to get some points clear so that you don't confuse them. You need to get some points clear so that you don't confuse them. Let me pull up the app. And Okil, I want you to read this one very quickly so that we move. I'm bringing the arc down to section 31. I should be projecting right now. You should be seeing the question right now. Read for us section 31.
So section 31, characteristics.
B, section 31B.
A person gives movable property, which includes any debt secured upon movable or immovable property, which he could otherwise dispose by a will.
So is your question answered?
Yes, it is. Thank you.
It must be movable. It must be movable property. Anything that is given under donation must be a movable property. If it is not movable, you can't give it under donation. So let us read the question. I wanted to start with this question quickly so that we can see something and then we get into the discussion today. Somebody read question 3 of 2021 June. Somebody read that question quickly. Someone can see it?
According to the traditions of the Wakanda tribe, it was a general rule passed on from generations that women were not entitled to own land. It was generally known that land had its owners, and these were not women. Thus, if a man was survived by daughters only and his wife, the deceased brothers would take charge of the administration of the estate, and if there were no brothers, the clan would select any member to be in charge. Married daughters were never considered beneficiaries of their father's estates, and unmarried daughters were not entitled to their own father's land, but would be shown a place to live and cultivate without any ownership or control rights. Divorced returnee women were shunned, and upon returning to their parents' home, would be shown a small strip of land to live and cultivate. The land title would always be in the name of the male figure in the family or clan. Administration of estates was applied for at the district commissioner's offices and the grant issued by the district magistrate. Unknown to the Wakanda people, the country came up with a new act known as the Law of Succession Act 1981. In spite of this new act, the Wakanda people continue to apply their traditions as regards matters of inheritance succession. Among the Wakanda people, there lived one Mr. Gitonga who owned a large tract of land and 2 town plots in the nearby shopping center. Mr. Gitonga was blessed with 3 daughters only. He contemplated marrying another wife to bear him sons, but before he could do so, he died abruptly on 1st August 1985. He was survived by his wife Josephine and 3 daughters. One daughter, Mercy, was married nearby, and the other 2 daughters, Zipporah and Gladys, were unmarried. Subsequently, the clan sat to discuss administration of the estate of Gitonga, deceased. They allowed his wife to continue living in the matrimonial home together with the unmarried daughters. It was decided that since Mercy was married, she was not entitled to a portion of the land. As the deceased had no brothers, the clan then appointed a cousin of the deceased, Mr. Maingi, to be the administrator. Kindly scroll, Council. Of the estate. Mr. Maingi then proceeded with administration through the local administration offices, and his application was sanctioned by the district magistrate Wakanda. The estate was subsequently distributed as per the traditions of the Wakanda people. In the meantime, Mercy was chased away by her husband, and she sought refuge in her mother's house. The clan allowed her temporary occupation in her mother's house, and they built for her a small mud house at the far end of her deceased father's land, where returnee women are normally settled. They allowed her to cultivate a very small strip of land, but not to own any land. Mercy was not comfortable, but she had no option. Sometimes in November 1990, the Pro Bono Lawyers Association visited the Wakanda Independent Church to give a talk on inheritance and property. Mercy, her sisters, and mother attended the talk. They were surprised that women were actually allowed to inherit and a title could be in the name of a woman. They took the contacts of one lawyer, and a week later, they were in his office seeking legal advice. Considering that they are caught in between custom and statute law, A, using case law and relevant statutory provisions, analyze the legal position as regards administration of the deceased estate in the context of the narrative. In your answer, state whether the deceased wife and daughters have a claim or not. 8 marks.
Yes. Yes. So this is a very easy question that we have discussed before. We have discussed this question before, which is a question of the distinctions between or the intermarriage between the law of succession as well as the traditional or the tribal or the customs. Okay, so you're being told that this person owned a piece of land. Mr. Gitonga was blessed with 3 daughters only. So that is where I'm projecting. I think I'm highlighting it actually so you can see it there. Let me change the color to something brighter. So Mr. Wakanda, among the people that live Mr. Gitonga, who owned a large piece of land and 2 town plots in the nearby shopping center. Mr. Gitonga was blessed with 3 daughters only. He contemplated marrying another wife to bear him sons, but before he could do so, he died abruptly. He was survived with one wife, Josephine, and 3 daughters. Okay, one daughter, Mercy, was married to the nearby, and the other 2 daughters, Zipporah and Gladys. Okay, so those are the people that were left behind. Now, Mr. Gitonga abruptly died on the 1st of August 1985. The 1st of August 1985. Now, this question is going to form the basis of our discussion today. So have it at the back of your mind. But what I want us to discuss now is part 2 of it. So we are going to talk about part 1 once we go through the first limb of our discussion today. And then part 2, we are going to answer it now. So part 2 says that name 2 instances where the Law of Succession Act allows for the application of African customary law. Name 2 instances where the Law of Succession Act will allow for the application of the African customary law. That is what I want you guys to answer quickly, and then you can go to our discussion today, and then we'll come back and answer the question whether or what will happen in terms of the succession of Mr. Gitonga's estate. Quickly, guys, what are the 2 instances we talked about? What are the 2 instances that we talked about? Number 1, Okile.
Where the deceased person dies estate and his property falls among the excluded property provided under Section 33.
So, come again.
A customary law will be allowed to be used under Law of Succession Act, where the deceased person, having died intestate, his property is located within the excluded locations provided under Section 33 of the Law of Succession Act.
Yes, that is the first instance. That's a very perfect analysis. Thank you very much. So we are saying that in the instance where, and I'm going to project that. I'm going to project that. So as I project that, Anyanzwa, give us the second instance.
I'm just hazarding a guess where the deceased person died prior to the Act, the 1981 Act.
Where the deceased person died prior to, what the hell is this? I don't know why it's showing me that. Can you hear me?
Yes, yes, we can.
I don't know what's wrong with my. Let me do that. Sorry. All right, so I want to start from the very top. The very top on what Anyanzwa has already said. So that is the first instance where the customary law is allowed within the law of succession is under Section 2. Okay, it is under Section 2. Okay, I hope you can see my screen. If you can see my screen, I am projecting Section 2. Section 2, I am projecting Section 2 here. Okay. All right. No response, but anyway, I'm projecting Section 2 there. I hope you can see it clearly. So Section 2 talks about the application of the Act, and the first instance is given under Section 2. What is it saying? It is saying that the estates of persons dying before the commencement of the Act. And what is the commencement period? The commencement is 1981. So the estates of persons that have died before 1981 are subject to the written laws and customs applying to the date of death, but nevertheless, the administration of the estate commences or proceeds so far as possible in accordance with the Act. So the law that is going to be applicable are the customs that were applicable during or at the time of their death. So if you died before 1981, then we are going to apply the law that is applicable to your customs. That is the first instance where we are going to have the customary law being used within the law of succession. That is the first instance where we are going to have the customary law being incorporated during the succession of an estate. When you die before the commencement of the Act. Guys, are we together?
We are together, Mwalimu.
All right, so that is the first one. So guys, anytime the examiner tells you that this person died on this date, now that person is not lacking something to do. That person is simply telling you that you need to pay attention to the dates, okay? You need to pay attention to the date. So anytime you're given the date, like you're given in the question above, that this person died in 1985, then you're supposed to understand that this person died after the commencement of the Act. Okay, the person died after the commencement of the Act, and therefore their estate will be distributed according to the rules of the Law of Succession Act. But there are two things you need to understand about what you can see on your screen. The first thing you need to understand about what you can see on your screen is this. Okay, there are two things. There is the distribution. Okay, distribution. The distribution of the estate, that one. And then number 2 is the administration. Okay, now distribution is different from administration. Administration is the law applying to the distribution, or I don't know how we can, let me give you an example. Okay, so if somebody dies today, distribution is person X takes this, person B takes this, person Y takes this. That is distribution. And then the administration is we have to apply for the grant. The administration simply means that before we distribute, we must first apply for the grant. We must first apply for the grant. Are you together? We apply for the grant before we distribute. So if you die before 1981, we shall still take out the grant according to the Act, because the administration is still within the Act. So we'll take out the grant as per the Act. But when it comes to once we take out the grant and now we are having distribution, we'll be asking ourselves, hey, what is the custom saying? What is the customary law saying in terms of the inheritance? So if the customary law is saying that women don't inherit, that is what we shall do. Okay, so we look at the customs in terms of distribution, but for the administration and the general purposes, we will still take the grant as per the Act. That is the Law of Succession Act. We file for the relevant grants within the relevant codes, within the relevant timelines. We take out the grant. Once it is confirmed, then the distribution will be according to the customs. Are we together? So that is the first instance. The second instance is under Section 34. Let us move down to Section 34, which is the second instance where, not that. Section 34 is the second instance where the law of succession will be applying, where the law of succession will be, the customary law will be applying. And just like Michael has already said, that in an instance where you die intestate, okay, you die intestate. Look at that. When you die intestate, under Part 4, intestacy, if you die intestate and you have the following properties: agricultural land, okay, you have agricultural land. That is the first thing. You die intestate, you have agricultural land, you have crops, and you have livestock. Okay. Now, these agricultural land, crops, and livestock are in the following districts. Okay, they are in the districts that are indicated there. Then the administration of your estate will not be according to the law of succession. It will be according to, the distribution of your estate will be according to the customs. So if you die intestate, this is intestacy. Intestacy means this person didn't leave behind any valid will. This person didn't leave behind any valid will. So there was no will. So if you die without a will and your properties, guys, your properties are within the districts that I've mentioned here, that is West Pokot all the way to Narok, then your administration of your estate shall be according to the rules of your customs. Okay, now that is Section 33. What does it say? The law applicable to the distribution on intestacy of the categories of properties specified in Section 3.2 shall be the law or custom applicable to the deceased person's community or tribe as the case may be. That is the rule of the law when it comes to somebody that dies intestate. So guys, what you need to understand there is, one, that the examiner knows exactly what you think about Narok. The examiner knows exactly what you think about Marsabit, Tana River, Wajir, West Pokot, and Isiolo, Kajiado. Now, they will not tell you the deceased person died intestate. They will tell you the deceased person died testate. Now, because you're looking for the district, you will not realize that that is a case of intestacy. Testacy. Now, where there's a will, this rule doesn't apply. See what I've highlighted in orange? Where there is a will, whatever highlighted in orange doesn't apply. It only applies during intestacy. Guys, tuko salama?
Yeah, tuko salama.
Yes.
Yes.
It only applies during during intestacy. So only in an instance where somebody has died intestate, there is no will, they have died intestate. That is when we shall have the customs applying if they had properties within the districts. So that is the rule. So in other words, you can still have a will. You can still have a will and bequeath your agricultural land, crops, or livestock if you have any. You can still bequeath them in a will in these districts. It only becomes a problem if you die intestate and you have these properties in the district. Now, guys, there is a test. There's a three-way test. Let me call it a three-way test. Okay, the first way test, or the first way is there must be intestacy, no will at all. There must be intestacy, no will at all. Okay, that is the first way. The second way is it must be agricultural land, crops, or livestock. The property in question is not a car. The property in question is not a car. It is agricultural land, crops, or livestock. And then the third test is that it must be within the districts, So even if you are given agricultural land, crops, and livestock in West Pokot, Wajir, Turkana, but it is testacy, then the law of the customs will not apply. What will apply is the tested succession. That's the law of the Law of Succession Act. If you're given a car, a house, okay, a bicycle in these districts, and this person has died intestate, this one will not apply because in that instance, the property does not meet the test. So intestacy, the property, the district, okay? The district, the property, the intestacy. That is the three-way test. So when you see Kajiado somewhere, don't rush and say, huyu, hii exam na uwa walai. If you're doing exams now, una feel like hii nimeua, chances are wewe ndo unakufa kwa hiyo exam. Okay, if you start feeling like hii namaliza walai, you need to step back, you need to calm down, things are not going your way, ni wewe unauliwa. Okay, so tulia. So when you see Kajiado, don't rush and say pass, hii ndo nilikuwa nangoja, ni wewe ulikuwa unangojewa. So just look at the three things. The first one is intestacy. Is it intestacy? Number 2, is it agricultural land, crops, or livestock? Number 3, is it within the districts? If it is not, don't argue for the law of the customs. And that is the answer to the question that was there in part 2. That is the question to do with instances where the law of succession allows for the application of the African customary law. That question is well answered. Now let us go to something else. That is the law of intestacy. So today, guys, we are starting on the law of intestacy. Okay, we are starting on intestacy. Now, intestacy simply relates to an instance where the person did not make a will. We have said before that a person can die testate or a person can die intestate. You can die testate or intestate. So testate means you have a will that you made. Intestacy means you don't have a will that was made. Testacy, there's a will. Intestacy, there is no will. So we are at a point where the person did not make a will. Okay, we are at a stage where the person did not make any will. Okay, that is where we are. So what happens if the person has not made a will? Guys, at any time you are discussing a question in succession or a question in probate, there are two instances. There are two sides to that coin. The first side of the coin is that there is no will, and therefore you deal with that as intestacy. The second side of the coin is there's a will. So whenever there's a will, oral or written, then you deal with it as a tested succession. So in the first part, we discussed tested succession, making of valid wills and everything on wills. Now today, I want us to move a little bit a notch higher and talk about what if there is no will. Okay, what if there's no will? And I've said before that the law of succession is about death. there must be death for there to be succession. Okay? If you're reading a question and nobody has died in that question, if you're in an exam and you're reading a question and no one has died, you're not in a probate exam. You need to check and move out and get out of that exam. You're not in a probate exam. Okay? If nobody has died in the question, there is no question that has, it's about death. Okay? It's about death, and specifically it's about the distribution of the estate of the deceased person. So once you've died, the distribution of the estate of the deceased person. Are you together?
Get together.
Guys, tuko sawa?
Yeah, yes.
Yes.
All right. Amazing. Amazing. Now, I think I've discussed the first part, so there's no need of us to talk about this rule again. Can you see the screen? Yes, you can. There's no need of us going through it again because I've just talked about it, the question of intestacy. Now, let us go and talk about the meaning and instances of intestacy. The meaning and instances of intestacy. Guys, probate is very simple. Probate is very simple, okay? Probate is one unit that you should be able to wake up at midnight, okay? You should be able to wake up at midnight and just sit down and do a full, even 10 papers back to back. You can do it, okay? So I want you to just understand the small concept. Don't be emotional. This is where also people get very, very emotional, okay? People get very, it is not real, guys. It's just an exam. It's not real. Probate is just, it is not real life. Okay, whatever you're being told in that story, in that paper, is not real. Don't cry. You know, some of you will be doing exam and are crying. You know, you're like, what's happening here? It's not real. It's not true story. Okay, so don't be emotional about it. It is just something that might happen. Okay, nobody cheated on anyone in that question. It's just stories that you're being told so that you can formulate an answer. So don't get mad, you know. Somebody will walk out of the exam room after doing probate and they're very, very mad. You're wondering why this person is so offended. They're offended as a deceased person. All right, so that is it. So what are the instances of intestacy? So the first one is what you're calling there is no will at all. That is the full intestacy. No will at all. No will at all. Okay, that is the first instance. There is no will at all. That is the first instance of intestacy. No will at all. Okay, no will at all. The second one is there is partial intestacy. Partial intestacy. So what is partial intestacy? The deceased person made a will to cover part of their estate and left the other part of the estate without a will. So if he had a car, so he wrote a will and bequeathed the car and left behind the land. So there's partial intestacy. Partial intestacy. And then is an instance where the deceased person made a will, but the will has been struck out. The will has been declared invalid. The invalidity of the will. Now, way out of this discussion, after this discussion, we shall be talking about something called contentious probate. Contentious probate. Now, under contentious probate, we shall be discussing things to do with objections, for instance. Now, objections, that is where we are going to have the question of validity of wills coming in. Okay, if you've been left out of the will, guys, you cannot object. There are two options available for you if you've been left out of the will. If I'll come to you today, let me pick someone. Let me pick somebody. Someone called Bishar. Are you there?
Yes, Mwalimu, I'm here.
All right, so I come to your office and I tell you that I was left out of the will. What are my two options?
So there are two options that you have.
What is the first question? What is the first question you'll ask me first? As you give me my options.
Why you have left? Why you are the deceased left you?
My friend, sit down. What are you saying? Let's talk to someone else. That is the wrong answer. Kamunyu Ndungi. Are you there?
I am present. The first thing I'll ask is, what is your relationship with the deceased?
That is an amazing question to ask. Yes. What is your relationship? Okay. And I will tell you, I am the wife. Okay. So what will you tell me?
Should I continue, or when?
Yeah. So
when,
if once I've told you I'm the wife, then what is the next thing? What are you going to do?
to know when exactly the union came to effect?
That is not your business. When you got married, is not your business.
The date,
That
the
is not.
year.
That is not the business.
Okay. The year, or whether it was formal or customary.
Again, that is not your. What are you going to ask me? Njoroge Masi, tell me. Now, I've told you I'm the wife. Huyu jamaa tulipendana na yeye kitambo sana. So, what is the next thing you're supposed to tell me or to do on your end?
I'll ask whether or not a grant has been confirmed.
No. Before you get there. Before you get there. Before you get there, what is I'm telling you I'm the wife. Masesi Tabitha.
I will ask if there's a will.
No, I've told you I was left out of the will, so there's a will. Alingo Penina.
Just a trial, Mwalimu. I'll ask when the husband died.
He died last year. That is not important. When he died is not important. Mondi Rachel. Guys, you guys are praying with me. Why are you praying with me?
I realized I was going to say the same thing that Penina said.
Abdisalan Gure, please.
Yeah, I believe Mwalimu, if the person tells you that she's the wife, then definitely she doesn't need to prove any dependency, and I will make an application for provision under section 29 where you ask for provision for dependence. I don't know whether I'm right.
You are close home. You are close home. But I want you to build on the first one you've said. The first one you've said.
Yeah, now that she's the wife, she doesn't have to prove any dependency at all.
Before you get there, okay? Before you get there, what do you confirm? Let me use the word. What do you confirm? The person has told you their wives. What do you confirm?
You have to confirm whether she's the wife or not.
Yeah, and in confirming whether they are wives or not, what are the things you look at?
Of course, you look at the marriage certificate, where there was any celebration or a marriage certificate or something like that.
Okay, there's whether there's a marriage certificate, number one. Number two?
Whether there was issues.
Which issues? You have issues yourself, I can see.
Whether they had children.
No, that is not a factor here. I don't have a child. She doesn't have a child. Okay. Fine. The first thing, guys, I will get inside this meeting right now and I'm tapenda. Okay. I will get inside this meeting right now and you guys will not like it. I'm asking again. So the Salan has already told us very well. If somebody tells you their wives, so you first confirm whether they're wives. So in confirming their wives, the first thing is a marriage certificate. Okay. Number two, Alingo Penina.
Another trial, a chief's letter.
What is a chief letter has to do with being a wife? Does the chief give you a letter when you get married?
No, but it writes that they know this person and you are
Whether the chief knows
bit,
you. The chief
yes,
doesn't
something
matter
like
whether the chief knows you or not. You are the chief knowing you doesn't mean you're the wife. You know, even the mother of the deceased person can know you. The mother-in-law can know you. The father-in-law can know you. But wait, one or two, you're not a wife. So Sembuse chief knowing you is not an issue here. Okay? The chief knowing you is not an issue here.
Okay, thank you.
Guys, we talked about this. That is the problem. Rachel.
If there is any proof of registration, if the marriage was not a Christian marriage.
That is still the question of marriage certificate. That is still pointing to marriage certificate. Apart from that, Kimaru Isaac, please guys, mmenurisha shala nyuma, tumerudi nyuma sasa.
I think you have to consider whether the marriage is still subsisting or the
How is
parties
this?
were divorced.
Where? Just sit there. Are you a devil worshipper? How is this subsisting and the person is dead? The husband is dead and he's telling you my husband is dead. How is he married to a ghost? My friend, are you worshiping under the water, under the sea? Guys, Owino, Eric, what are you looking at? If I come and tell you that, okay, I was a wife, Abdisalana said, marriage certificate 1. Number 2, what is? Eric?
I'll ask whether why then she was left out of the will.
How is that? Sit down, my friend. Dagane, Aisha. Hey,
Mwalimu, I'll ask if she has any wedding photos as evidence.
Wedding photos, picha unaweza piga na uwe mwanaume lakini bado hajakuoa. Picha tu, hiyo mtapiga mingi sana. Gallery itakuwa imejaa lakini that is still not marriage. What else? That is not a point. Manga, Janine.
I can try. You need to also ascertain which marriage it was, if it is civil or customary.
So that is still part of the marriage certificate or evidence of the first marriage. What else am I looking for? Saina George.
Yes, after confirming that I'm the wife to the deceased, and then I'll also have to confirm that I'm a dependent under Section 29, and therefore I'm entitled.
No, you don't need to confirm whether you're dependent once you know you're a wife. So we are still ascertaining whether you're a wife. What do we look at? Waire.
Yes, I'll ask you.
Okay, let me.
Other surviving spouses, other surviving wives.
What do you mean other surviving wives? She is a wife. Unamuuliza kama kuna mabibi zingine?
Ndivyo tujue how to divide anyway.
Una divide nini? Hey guys, okay, let me ask the question in a different way. Okay?
How many years?
How many years doesn't matter. Let me ask the question in a different way. The person comes to your office and they're telling you, I was left out of the will. She's crying. And then you've asked her, are you having a marriage certificate? Amekuambia sina. Okay? Sina marriage certificate. That is the first question you ask. Do you have a marriage? What was the relationship? I was married to him. Do you have a marriage certificate? Sina. Okay? Were you married under customary law? No. Did he pay dowry at your home? No. Did he take you to church? No. Did he take you to the AG's office? No. What else? That's what I'm asking you. What else now? No marriage certificate. Wamboi.
Could we ask whether she has proof of reasonable provisioning?
Hey. Mwana wa Bikira Maria. No, you can't. Tianga Jennifer. Guys, I taught this in this class.
I think you'd be asking the questions to satisfy whether she's a cohabitee.
That is a good point. So, do you have a marriage certificate? No. Are you a cohabitee? Were you a cohabitee? Are you a common law wife? Let me call it. Don't call him a cohabitee. Are you a common law wife? That is the next question. Okay, that is exactly what I'm asking. This person is saying is a wife. Umemuuliza, are you married? Yes, I was married to him. Marriage certificate iko wapi? Sina. Okay, fine. Are you a common law wife? Amekuambia hapana. Next question. You guys are playing. Bishar.
Normally, the first time that you asked the question, you said that there was a certificate of marriage. That's why we've gone to all those wrong answers. But now, if that client says that there's no marriage certificate, you will just ask because they don't understand this language of whether she's a cohabitee or common law. This we assume that this a layman person. We establish the fact whether that is a common law marriage. And you go for the element of that common law marriages that comes to the qualitative and quantitative aspect. You ask whether they were living together, how they carry themselves.
That is common law marriage. That is common law marriage. Are you married common law wife? You established that as well. You established that was a no. Next.
So now you ask whether the deceased has left some, wealth before.
Well, Kachini. What do you mean wealth? Wealth? How is wealth related to marriage?
If you have provided
guys,
before,
what is the
you have given gift. If there was a existing gift.
What do you mean, guys? You're answering the wrong question. Masesi Tabitha, what is the last question you're going to ask? First, this person has told you, no, I'm not married under charge, under statute, or under customary law. Okay. Are you a common law wife? Amekwambia hapana. Okay. Third one. What else? Masesi Tabitha.
I will ask whether the cohabitation, the prolonged cohabitation, gave rise to the presumption of marriage.
That is under point 2. Are you a common law wife? Or Tensawa Njiku Yawe versus public trustee, the common law wife, the cohabitee. That is the question. That is the second question. Now, amekwambia hapana. Third question is which one? Kamunyu Ndungi.
Did he leave a will or not?
Yes, Christo. All right. Kezia.
Would ask for how long have they lived together so that you can
that
know.
is still part of guys, when you are establishing the second point, let's start from the first point. Marriage. You're confirming whether they were legally married. You're confirming the first point. Were they married in church? No. Were they married under statute? No. Were they married under customary law? Was there any dowry paid? No. You're done with that point. Number 2, are you a common law wife? Otensaya Wanjiku Yawe versus public trustee. Okay, that was affirmed in the Supreme Court last year. What do you do next? You proceed and confirm whether she's a common law wife, long cohabitation, issues, properties, intention to get married, public perception. All those points were under Otensaya Wanjiku Yawe versus public trustee. Hiyo pia hapana. Next question. Mudhoni Murimi.
I would want to confirm whether they are a woman under section 3.5.
Thank you very much. May the Lord bless you until you can't walk. So that is the answer that I'm looking for. Okay? Guys, I have said there are three people we consider wives under the law of succession. The first person is a wife under the Marriage Act. The first person is a wife under the Marriage Act, and that person is the wife married under the under church, under statute, or under any customary law. Okay, that is the first person we are calling a wife. So if you don't meet that test, the second person is a cohabitee, a common law wife. So you confirm whether they are common law wives. Okay, they have said no. Then the last person, before we can conclude that you're a wife, is the woman under section 3.5, which is a woman for purposes of succession. So you ascertain that as well. And then you conclude that they are wives. So the moment you say you are a wife, either through Marriage Act, cohabitation, or under section 3.5, then automatically they have qualified for section 29, which is the dependent. So they are dependent under section 29. Okay? And if they tell you they are children of the deceased person, what do you ask? Okay, they have told you that this person was my father. What are the questions you're going to ask? Or what are you going to establish? Number one, quickly. Jennifer, Younger?
Whether it is the biological parent.
Okay, the biological parent. Two. Nyangaus, Kita.
In the case that they are not their biological parent, I would need seek to establish whether the deceased was maintaining them prior to their death or not.
In case
the deceased was not their biological parent, I would seek to establish if they were being maintained by the deceased prior to the death or not.
Okay, so the next one is maintenance, but maintenance comes from what? A child who has been taken in. And then lastly is if they're not biological and they are not also being taken care of by the deceased person, or they are not taken in by the deceased person, what else do you ask? Let's talk to Mwendwa, Damaris.
Whether they fall in the category described in section 29 of who is a dependent.
Wewe nakuona sana. Abdisalan Gure. Tianga Jennifer.
Whether they are legally adopted.
Thank you very much. So adoption. Okay. So you've confirmed that they're dependents. What else will you advise them to do? They've been left out of the will. What else do you advise them to do? What is the next question you're going to ask? Remember, we are answering the questions of what are their options. Okay. What are their options? So they have told you their wives or their children. You've ascertained that. Now, what is their options? What is the next question? Abdisalam?
Yeah, then you make an application under section 29 for
Before you make the application, what do you consider? Before you make the application, what do you consider? Kamiri John.
Why were they left in the will?
Sit down, my friend. What are you saying? What do you consider?
Like, for example, if they are the ones who are beating their dad.
No, but we are not talking about what kupigana. No. That is not you. That is a court. The court is what we will consider that. That is a decision of the court, not you. Okay? You are a lawyer. You're not a judge. Okay? So what are we considering? What else are we asking? Before we know the two options that we have, guys have said, what are the two options? We've not answered the two options yet. The first one we've established whether they're dependents. And for us to know whether they're dependents, we are asking ourselves, number one, are you the wife within the three categories? Yes, you are. Or are you the child within the three categories? Yes. So we have established that. Or are you a former wife, or are you a widower? Okay. Or are you the deceased person's stepchild, stepbrother, stepsister, grandmother, grandfather, mother? Are you that? Okay, and then we go to the next question. Now, what is the next question? Before we get our two options, what are the next questions now? Kato Alex.
Whether the grant has been confirmed.
Thank you very much. Whether the grant has been confirmed. Okay, so while at it, Alex, what if the grant has not been confirmed? What is our first option now?
We can apply for the limited grant to be set aside or revoked.
Wewe maonja bangi, si ndio? Maonja kitu. What do you mean limited grant to be set aside? We are not, grant has not been confirmed. There's no grant here. There's no grant. Let's say there's no grant. No grant has been confirmed. What is our first option?
We can apply to revoke the will.
Why are you revoking the will? Are you the deceased person? Are you a devil worshipper? The will cannot be revoked once the deceased person has died. It is only the deceased person that can revoke the will. Guys, the deceased person only can touch his will unless you are his ghost. The will cannot be revoked.
To declare the will invalid.
The more you speak, the more you say wrong things. Just keep quiet and drink some water. Okay? So you've answered the right question by saying we confirm whether the grant has been confirmed. Okay? It is not confirmed. What is our first option? Zaweria.
Protest.
Okay. Jesus Christ from Nazareth, Bethlehem, Judah, the Lion of Judah. Okay. Kamunyu Ndungi.
You apply as an administrator and the court will join you into the...
Where? Joined where? Join yourself to your seat. Join yourself back to the seat. Hey, hizi ni gani? Hizi ni mambo gani haya? Hizi ni mambo gani? Hey, ni ngumu kidogo. Masesi Tabitha. Guys, listen. Before you speak, Masesi. Now, guys, I have come to your office. I have asked you. I've been left out of the will. I am crying. You're asking me, are you a dependent? To identify whether I'm a dependent, you've taken me through the test. So you have confirmed I'm a dependent. Tick. Okay? Number 2, Katho Alex has already told us that you confirm whether the grant has been confirmed. Grant is not confirmed. Now, once you take those questions, what are now my first option? Okay? My first option is, what do I do? Do I just continue crying? Katho Alex.
You make an application for reasonable provision.
Thank you very much. That is what you needed to have said first. Okay, so if the grant is not confirmed and you're a dependent, you make an application under Section 26, reasonable provision. You make an application for reasonable provision to tell the court to give you something. Guys, I have taught this twice, Atta. You make an application for reasonable application. So I mean reasonable provision that the court do give you something reasonable. Okay, because you've been left out of the will. You've been left out of the will or intestacy. So if the grant is not confirmed yet, you will make an application for a reasonable provision. Now, for you to make an application for reasonable provision, there are 2 things that must happen. Guys, there are 2 things that must happen. The first thing, you must be a dependent. This person that is coming to your office must be a dependent. It means kama hao si dependent, kama yeye anasema tu huyu jamaa wametoka nayo mbali, alikuwa beshte yake ama nini, that is not dependent. They cannot inherit from their estate. So they don't have the capacity, the locus to bring an application under Section 26, what I'm projecting right now. So for them to fall under 26, they must be the people listed under Section 29. Okay, they must be the people listed under Section 29. And who is listed under 29? The wife, former wives, children, stepsisters, stepbrothers, the widower, that is the man. All those people are listed under 29. So if they're falling under 29, you don't advise them to apply yet. You still ask them, is the grant confirmed? That is a second consideration. If the grant is not confirmed, then your option is here. where the person dies after the commencement of this act, insofar as the succession of his property is governed by the provisions of this act, then on application, you make an application under section 26, which is for reasonable provision, that the court to give you a reasonable provision. Okay. Now, what if the grant has been confirmed? Because if you look at section 30, section 30 says, let me give you section 30. 30 says that no application under this act may be brought for a grant of representation in respect of the estate to which the application refers. Okay, let me read that again. Let me highlight it first and then read. No application under this act, this part, shall be brought after a grant of representation in respect of the estate to which an application refers has been confirmed as provided for under section 71. So if you have made an application under section 71, there is no confirmation. Sorry, there's no application under section 26. So if they tell you that, yes, grant has been confirmed, or if you can see from the question, the grant has been confirmed, what is now our last option? Last option is to, yes, Nyambura.
Revoke the grant.
Thank you very much. To revoke the grant. So you revoke the grant on the grounds listed under section 76. Guys, that is what I wanted you to understand. So it seems like you guys still don't understand it, because that is the backbone of all the questions you'll be you'll be doing in probate. So let's go straight into the rules of intestacy. The rules of intestacy. So I've said there are 3 ways of intestacy. There are 3 ways. The first one is there's no will at all. There's a partial intestacy. There's a will covering some properties and the will not covering others. That is partial testacy and partial intestacy. And then also in an instance where there was a will, but the will has been declared invalid. Okay. Now, I have said, if somebody comes to your office and they are saying they've been left out, that is not protest. That is not objection. Okay. That is not protest. That is not objection. Are you together? Fine. Now let us go and talk about the first instance. Now, the next thing you need to understand before we get into the second instance, or the first instance, is that the law of intestacy, okay? The law of intestacy does not favor anyone who is not the child or the wife or the spouse. Okay? If you're not the child, you are not favored. Okay? If you're not the child, you are not favored. If you're not the wife, you're not favored. Okay? Guys, are we together? If you're not the child, you don't get anything. If you're not the spouse, you don't get anything. So when it comes to the rules of intestacy, it only favors the immediate nuclear family. And it can only go out of the nuclear family if the nuclear family is not there. So if we are going to talk about the rules of intestacy, the rules of intestacy are rules that are applying to the distribution of the estate of the deceased person where the deceased person has died intestate. Where the deceased person has died intestate. If the deceased person dies intestate, okay? If the deceased person has died intestate, okay? You need to understand that. If you die intestate as a deceased person, then what are we going to do? We are going to apply the rules of intestacy. Why are we applying the rules of intestacy? It's a very simple rule. Why are we applying the rules of intestacy? We're applying the rules of intestacy, guys. We are applying the rules of intestacy because you did not leave a will to tell us how to distribute. The will shall tell us how to distribute. But if you don't leave a will, it means sisi hatujui vile unataka tufanye na hii property. We don't know what you want us to do. So because we don't know how the property is supposed to be distributed, we shall distribute it according to the rules of intestacy. So the rules of intestacy only relates or simply relates to the distribution of the estate of the deceased person, where the deceased person did not give directions in terms of how their properties are supposed to be distributed. And that is why one of the reasons why somebody needs to make a will is that they can avoid the rules of intestacy. Okay, so what are the rules of intestacy? Rule number 1, somebody who is reading clearly can read for us rule number 1. That is section 35. That is where the first rule is. And the first rule, as I've highlighted, is where the deceased person or the intestate has left one surviving spouse and one child or children. So if you died and you left behind your wife or your spouse, let me call it a spouse, okay, and your children, child or children, that is the first rule. Okay, that is the first rule. So what happens if you left behind your wife or your husband and your children or your child? What is the rule? How do we distribute? Read for us section 35.
Subject to the provisions of section 40, where an intestate has left one surviving spouse and a child or children, the surviving spouse shall be entitled to A. The personal and household effects of the deceased absolutely, and B. A life interest in the whole residue of the net intestate estate.
Yes.
Provided that
No. This one has been deleted. This one has been declared unconstitutional, and I'm going to explain that in a minute. So the first rule. So guys, if you've been told that Bishar, okay, was a millionaire and he left behind this, and this, and he was survived by the wife and 3 children. So that falls within the first rule, okay? The wife and the 3 children. So you need to tell us what is the wife getting and what are the 3 children getting? Because from here, you will draft for us what you're calling the schedule of distribution. The schedule of distribution is drafted in terms of intestacy. It is drafted in intestacy. So how do you draft it in intestacy, or why do you draft it? Because under testacy, the will is the schedule of distribution, because the will say person X takes this, person B takes this. But because we don't have that will, we prepare our own schedule of distribution as the administrator, okay? The administrator will prepare the schedule of distribution. Now, the schedule of distribution must adhere to the rules of intestacy, okay? Which is number 1, where the deceased person left behind one surviving spouse and the child or children. How do we distribute their estate? The first one, the surviving spouse, whether the wife or the husband, will be entitled to the personal and household effects of the deceased person absolutely, okay? Kama ni wig, bibi yako aliwacha wig na hizo vitu zote, ni wewe utakuwa unapaka hizo. Makeup ni yako, wig ni yako, utakuwa unafanya vile unataka. Okay? Those are the personal and household effects. All the personal things that belongs to the dresses, utavaa ukipenda. Those are your things. Okay? Everything that your husband left, everything, the personal things that your husband left, okay? Be it a suit, watch, socks, whatever, you know, those are your things as the wife. And that's what you're being told right now. You know, there's a verse in the Bible that says that you need to store your things in heaven. Okay, store your things in heaven so that when you go there, you will get them. Now that applies here. Okay, some of you are fond of buying your wife or your husband's just socks on their birthday. You're just buying socks and boxers. Akikufa, wewe utabaki na hizo socks. So imagine if you bought something expensive, utabaki tu nayo. So hizo socks 200 umebaya hapo, ni wewe tu utabaki nayo. They'll be yours. Malipo ni hapa duniani. Umesikia? So as you prepare for your man's birthday, please think about section 35A. Okay, that says the personal and household effects are yours absolutely. Hizo socks za black, kila birthday socks 10, kila birthday socks 10. Hizo ni zako. Utazivaa mpaka uchoke. So everything that that person, okay, everything that that person left behind, personal and household effects, so long as they're in the house, personal and household effects, they will be yours. So if you are investing thoroughly in that person, you will be smiling to the bank, you know. But kama wewe ni gang ya socks, malipo ni hapa hapa duniani through section 35(1)(a) of the Law of Succession Act. So all the personal and household effects of the deceased person will belong to you absolutely. And what is the meaning of a personal and household effects? Okay, number one, they include all the things that the deceased person used to use, his personal things, his books, his laptops, his phone, everything. Okay, everything. Kila kitu itakuwa yako. Okay, and then the household effects. What are the household effects? Household effects are everything that is within the house. Everything that is within the house. Okay, excluding a car. Car is usually outside. So excluding it. So everything that is within the house, that is a household effect. Personal effects are the things that belong to, even in that house, you know, the things that belong to the wife and the things that belong to them, to their husband. Okay, so if your wife dies, everything that they own, if you miss them at night, unavaa nguo zao. Okay, so those things are yours. That is the first rule. So what am I saying? If you get a question asking you how to distribute the estate of the deceased person in that instance, and you can see clearly that the deceased person left behind a watch, a jacket, maybe some jewelry, laptop, phone, and then you're being told to draw a schedule of distribution. You're just going to indicate there. If the wife is called Monica, Monica will take all the personal effects, absolutely. That is the first distribution. The personal and household effects, absolutely. They will belong to the surviving spouse. And that applies to both male and female. Tuko sawa? Tuko sawa. Now, the second one is a life interest in the whole of the residue. In the whole of the residue of the net estate. The whole of the residue of the net estate. What are we saying? We are saying that whatever remains, the net estate is, ukitoa deni zake zote, umelipa madeni zake zote, whatever remains, shamba, pesa, manyumba, magari, shares, hizo zote, those are the things we are calling the residue, the net residue, or the net intestate estate. All that will belong to you, but not absolutely. Okay, the first absolutely here under subsection A is, it means that you can go and sell it. Ni yako, utafanya nao kenye nataka. But on the remaining things, you can only enjoy a life interest. Life interest simply means that as long as you're alive, you will enjoy it. As long as you're alive, you will enjoy. Kama ni gari utaendesha mpaka ukufe. Kama ni shamba utalima mpaka ukufe. Kama ni nyumba utaishi hapo mpaka ukufe. Kama ni rental utapata hiyo rent mpaka ukufe. That is a life interest. You will enjoy a life interest. Okay? Now, there's something I've highlighted in color yellow. You can see that is color yellow. There's something I've highlighted right now in color yellow that says that there's a proviso that says that if the surviving spouse was a widow, then the life interest shall determine upon her remarriage to any person. Okay, that was supposed to curtail. I don't think whether they had this, when they were writing this, they had the wife inheritors in mind from Luo Nyanza. People that can't wait for the deceased person to be buried. Hata siku ya matanga ndo wanafika na makuti zao. So this one simply says that if you marry, then you will not enjoy the life interest. Okay, so this is a rule to tame the wife inheritors. Amaka Uncle Gashoki. If there's an Uncle Gashoki somewhere from Nyeri. So if you get Uncle Gashoki as the surviving wife, your life interest terminate, inaisha. So you stop enjoying anything on that property. Okay, but they said that is unconstitutional. They say that that is unconstitutional. Okay? They say that is unconstitutional. Now, initially it was intended to have the deceased person's property remain within his estate. Okay? There's a beef between the Kikuyu parents and the Luo parents. There's an unsung beef between the Kikuyu parents and the Luo parents. You know, if you're a Luo and you're growing up, you'll be told, zurura Kenya mzima, we kama kijana, zurura Kenya mzima, lakini usijaribu kuguza Murima hapana kuenda. That is the constitution. If you're a Luo kid and you're approaching the age of marriage, you know, you'll be told, my son, zurura Kenya mzima, ukitaka kwenda coast, northeastern, Narok, eastern, western, lakini usijaribu kuguza wapi? Kuguza Murima. The same lesson is given to the Kikuyu kids. Don't touch a Luo. So that the reason, I don't know why Kikuyus do that, but I know why the Luos do that. You know, one of the reasons they do that is from the SM Otieno case. You know, the reason the Wambui in SM Otieno case. So they believe it's not true. Of course, it's not true. And of course, the research has shown it time and again that the kind of bond between the Luo men and the Kikuyu women is unbreakable. Time and research has shown that. But they believe that if you die, they will disappear with everything that belonged to the deceased person. And that was the SM Otieno case. Remember the facts from SM Otieno case? So it was believed like that. So it is not true, of course. It is not true. And that beef is very funny. I don't know where it came from, but it is very, very funny. You know, even politically, they don't meet eye to eye, which is funny anyway. But anyway, it was actually, if you followed the SM Otieno case, and of course you know SM Otieno, if you're in this class and you don't know SM Otieno was one of the best criminal lawyers that ever lived in the history of Kenya. He was married to Wambui, and they were living in Karen, somewhere along Gong Road. And when he died, there was a dispute. And then Wambui got remarried again and squandered the estate of Otieno. And then there was a dispute in terms of where do we bury the body? Do we go and bury the body in Siaya, or do we bury it in Karen or wherever? But anyway, so normally African parents believe that not just even Kikuyus and Luos, African parents generally believe that the mothers-in-law, they believe that their daughters-in-law are trying to steal their son and the properties of their son. I don't know how true that is, but it is what it is. So that is one of the reasons why we have that provisions under section 35, the proviso under 35, because these things don't come out of the blues. They don't just come out of the blues. If Parliament sits down, they are considering the things, the matters on the ground. And during that time, when this act was enacted, it was believed that that was the reason. And that's why they said that if you are married to the deceased person and the deceased person dies, you will stay single. If you want to enjoy the estate of the deceased person, you will stay single. Okay? And if you remarry, if you get another person to marry you again, if you are the widow, then you stop enjoying the estate of the deceased person, and you should go and enjoy the estate of the person that has married you. And as a matter of fact, everything else that you are enjoying, you need to give to your mother-in-law and your father-in-law. That is under section 39 of this act. So everything else you're supposed to give to your mother-in-law. That was the law. It has been the law until last year. So you can imagine since 1981 up to now, and I'm very sure it existed long before 1981, that if you dare get remarried, then everything else that the guy used to have should go to the mother or the father. Okay? But again, things have changed nowadays. So 35, the proviso under section 35 was declared unconstitutional. But also, you know, qua ground vitu ni different. Qua ground vitu ni different. The deceased person property will be sold even before they're buried. Sometimes it happens like that, sadly. So the court in last year said, the High Court said that this provision was unconstitutional, and therefore every surviving spouse has the right to enjoy a life interest, whether they're married or not. So you are allowed to remarry, but also you are also allowed to enjoy the estate of your deceased person. Okay. Sawa sawa. So that is 35. So that is the rule under 35. That is the rule under 35. Okay, that is the rule under 35. So what is the rule under 35? That if you die and you leave behind a wife and your children, or your husband and your children, your husband or your wife will be entitled on the first ground absolutely to all the personal and household effects. Hizo ni zake. If you're drafting the schedule of distribution, those personal and household effects will go to the surviving spouse. And then number 2, this surviving spouse shall enjoy a life interest in the remainder of the estate. A life interest in the remainder of the estate. Okay, that is the first one. Then number 2, what is the children supposed to get? What are the children supposed to get? Now, this also was an inspiration from the traditional, because remember, this act is very traditional. This act draws from the traditional things within the society. How the society is used to relate, that is how this act was enacted. Okay, so you guys know very well that in your traditional homes, I don't know how it happens in your communities though, but where I come from, what normally happens is that if your father dies and leaves behind an estate, then your mother will enjoy that estate until her old age. And normally after your mother becomes old enough that she's now starting to predict her last days, she will normally call the family and tell you that my firstborn son, this land behind the home is yours. My secondborn son, this land next to the gate is yours. My daughter, you will get the land next to the river. And my lastborn son, this compound that we are staying in, the family home is yours. I'm sure it happens like that in almost all communities. So that is called a power of appointment. That is a power of appointment. That is a power of appointment, and it was lifted directly from the conduct. Let me highlight that, the conduct of the Kenyan community, so that the remaining spouse will enjoy the life interest until the point where they're suspecting that they're almost dying. So your grandmother will walk your fathers. If you still have a grandmother, you realize that now your grandmother will be telling your father that this is your land. She will tell your uncle, this is yours, without writing any will. And that is the law. And you know that in those communities, in those families, once your grandmother says this is your land, nivo, there's no question, there's no whatever. So that is what we call a power of appointment. So the children will only inherit as a result of a power of appointment, which is done by the surviving spouse. And let me read for you. 2, a surviving spouse shall, during the continuation of the life interest provided by subsection 1, have a power of appointment of all or any part of the capital of the net intestate estate by way of gift, taking immediate effect among the surviving child or children, but that power of appointment shall not be exercised by will, nor in such a manner as to take effect at any future date. And that is why if your mother in her old age tells you that this land next to the river is yours, everybody respects that. Okay, so due to that, it was adopted like that in the act. So that is what happens also in the act, that if your father dies and leaves your mother with things, those things belongs to your mother, and stop fighting your mother for the things of your father. You don't know how those people met. You don't know how they made whatever you're fighting for. So you need to relax and go hustle like other men. Don't fight your parents over the wealth of their spouses. They are supposed to enjoy a life interest. Life interest simply means wanakula, wana enjoy mpaka kifo. So while they're still enjoying, they can give you as the children through a power of appointment. Okay? They will give you through a power of appointment, which is you take this, you, my daughter, take that, you take that. Simply that, appointment. And literally speaking, in the villages, they just point that that one is yours. That one will point, that one is yours. That is the power of appointment anyway. Literally like that. Okay, so that is how children will get to benefit through power of appointment. Through power of appointment. So that is the first rule. What is the first rule? The first one is all personal and household effects will go to the surviving spouse, number one. Number two, this surviving spouse shall enjoy a life interest in the remainder of the estate. Number three, the children will enjoy the estate through power of appointment by the surviving spouse that can happen anytime during the existence of the life interest. Are you together? So that is the rule. Now, what happens if a child is not happy? If you're not happy if you're not happy with what you've been given through the power of appointment, if you're a child and you're not happy with what you've been given through the power of appointment, then you go to court, okay, under section 35. Let me take you there, okay? Here, there, you go to court, okay? You go to court. So when you go to court, what are you doing? Where any child considers that the power of appointment under subsection 2 has been unreasonably exercised or withheld by the surviving spouse, he or if a minor, his representative may apply to court for an appointment of his share with or without variation of any appointment already made. Okay, so if you think that your mother has favored some of your siblings than you, then you go to court and challenge the power of appointment through an application. This application is made under section 35 and it is made within the rules. That is the probate and administration rules, and that form is a standard form. Okay, it is in form of summons, which is a standard form in the rules. So you go to court through the power of through an application, and you ask the court to give you something reasonable, to add you something on top of what your parents or your mother has given you or your father has given you through the power of appointment. And of course, the court will consider everything that is under section 27, which is the same thing under section 35(4). So look at the nature of the deceased person's property, why the surviving spouse did not give you why your mother didn't give you something, your conduct in relation to the deceased and the surviving spouse. This is very, very important. If you used to disturb your father, and then after your father died, now you're still disturbing your mother, you will not get anything. And the court will consider that. And I've told you, this act was enacted in a clear reflection of the society. So how the society behaves. So we look at your conduct. Are you a stubborn child? Were you disturbing the deceased person? And have you been disturbing the surviving spouse? If yes, kula kiburi. Okay? So those are the factors the court will consider when the court is making a decision whether the surviving spouse has been unfair to you or not. That is the rule. That is the rule. That is the rule. That is the rule. So 5 is not important because it was declared unconstitutional. Let us go to the second rule. So are we clear on the first rule, guys? Are we clear on the first rule? Sema ndio. We are together on the first rule. So let us go back to the question that I shared. Let us go back to the question that we read. What is the question that we read? Now, in this question, you're being told, among the Wakanda people, there lived one Mr. Gitonga who owned large tracts of land and 2 plots in the nearby shopping center. Mr. Gitonga was blessed with 3 daughters only. He contemplated marrying another wife, but he did not do that because he died in 1985. He was survived. This is what I was looking for. Let me highlight it for you. So I can't highlight that one. I think it is, okay, it's not highlightable. So he was survived by his wife, Josephine, and 3 daughters. He was survived by the wife, Josephine, and 3 daughters, and he died intestate. So how do you distribute that estate? Number one, you realize this person died after 1981, so the act will apply. The rules of intestacy will apply, okay? That is section 35. So everything will go to Josephine. That is the personal and household effects will go to Josephine. And then number 2, the 3 daughters will be inheriting as per the power of appointment, because Josephine will be enjoying a life interest in the whole of the residue, that is the large tract of land and 2 plots at the nearby shopping center. So if you see such an instance where the deceased person left behind a spouse and children, then section 35 will come in. Let us go to section 36. Let us go to section. Guys, are we together? Am I making any sense?
Yes.
Yes.
All right, so let's go to section 36, which is the second rule. The second rule is where the intestate has left one surviving spouse, but no child or children. Okay? So in this instance, the deceased person left behind no child. Alikuwa tu na bibi ama alikuwa na bwana na they were not lucky to have a child, or they didn't want to have a child. So by the time he was dying, he didn't have a child. So no child is in question. No child is in question. So what is the rule? How do we distribute that estate? Again, the law is very clear. So you just look at the question and ask yourself, this question, where does it apply within the rules? So rule number 2 is where the intestate has left one surviving spouse, but no child or children, the surviving spouse shall be entitled to, or shall be entitled out of the net intestate estate to, number 1, same story, the personal and household effects, absolutely. Personal and household effects, absolutely. So all the personal and household effects of the deceased person will belong to the surviving spouse, absolutely. Ni yake. Number 2, the first 10,000 shillings or 20%, whichever is greater, absolutely. Again, okay? What is the meaning of that? So we value the estate, we value the estate. Now, the first 10,000 out of that estate will belong to the surviving spouse, or 20% of the estate. Okay, so this act was enacted in 1981. 1981, 10,000, where unaweza tesa mpaka uteseke tena na utese tena na uteseke tena, bado kuna 10K. 10,000 was a lot of money in 1981. Okay, so it is a lot of money. So the rule was you either get the first 10,000 or 20%, whichever is higher. Okay, 20%, whichever is higher. So if the deceased person left behind a spouse, okay, no child, he left behind his personal items, and he also left behind a 20 million worth of estate, then what is the spouse supposed to get? The first thing they're going to get are the personal and household effects. Number 2 is 20% of the 20 million. This one will be transferred to the wife. The wife will squander, akule, enjoy, atulie. And then the 80% remaining, the spouse will be enjoying, what are we calling that? A life interest in the whole of the remainder. A life interest in the whole of the remainder. So she will enjoy the life interest. So that means that for the 80%, she will not transfer to her name. No, it's not hers. She'll just enjoy a life interest. But the 20% will be transferred to her, as well as the personal and household effects. Okay? Provided, and remember, the personal and household effects, all the time where the spouse is remaining, the personal and household effects will be left to the surviving spouse. And I've said what a personal and household effects are. Okay? Everything that this person had, laptops, phone, everything. But wakuficha simu, that phone that you're hiding, you don't know what section 35 and 36 are saying. Once you die, atakuwa nayo na password kila mahali. Facebook, kila mahali atakuwa na password. Ataona vile ulikuwa na simp ukiwa alive. You will be ashamed even in your death. So please, just know that that phone that you're having is only yours for a few days. Okay, so the personal and household effects will go to the spouse. And then number 2, 10,000 or 20%, whichever is higher. So you look at 10% is higher, sorry, 10,000 is higher or 20% is higher. Normally 20% is usually higher. And then you go to the life interest in the whole of the remainder. Now this one, again, this one was declared unconstitutional. Let me just highlight it in red. It was declared unconstitutional. So the life interest will not terminate even when they are remarried. The life interest will not terminate even when they are remarried. Now, this is what I was telling you in terms of the SM Otieno case and the beef between watu wa Murima na watu ya Iluo Nyanza. This is the beef. Okay? So upon the determination of a life interest created under subsection 1, the property subject to that interest shall devolve in the priority set out in 39. What is 39 saying? You take to your mother-in-law and your father-in-law. That cannot happen in real life. I mean, it should happen. Okay, it should happen. But qua ground, the daughter-in-law will not give back 80% of the estate to the mother-in-law. That, okay, this is your son's things, 80%. I've taken my 20%. Please enjoy. Oh, enjoy where? That will not happen. But anyway, the court declared it unconstitutional. So there is nothing like life interest ending. So until it will only end if you die, not if you get remarried. I hope that is clear. So that is the second rule. Second rule is there is just the wife or the surviving spouse and no child. Surviving spouse and no child. Okay, now this is a continuation of what we are just saying right now. That is under section 37, which is the powers of the spouse during the life interest. The powers of the surviving spouse during the life. What can the surviving spouse do during the life interest? Guys, master this section. A surviving spouse entitled to a life interest under the provisions of section 35 and 36 with the consent of all co-trustees, okay? And the consent of all children of full age, okay? What am I doing? All children of full age, or with the consent of the court, okay? May, what can they do? During the period of the life interest, sell any property subject to that interest if it is necessary for his or her own maintenance. That one means his or her own maintenance. His or her own maintenance. Are you together? His or her own maintenance. And then number 2, provided that in the case of immovable property, it can only be done by the consent of the court. So let me explain that. So you as a surviving spouse, when you're still enjoying a life interest, you have the right to sell the part of the estate for your own maintenance. Unaweza uza shamba na ujikimu na I don't know whether ni kuekimu ama kuikimu. Waswahili knows better. But you can sell part of the property to survive on. Okay, buy food, pay your rent, all those things. But before you do that, you must get the consent of all your children that are above the age of 18, of all the court trustees. The court trustees, if you add 2 administrators, one of the administrator will become a trustee. So you'll get the consent of that administrator and also the consent of the court. So you can sell part of the estate so that you can, if it is a car, you can sell the car so that you can survive. Provided that if you want to sell land or a building, you must get the consent of the court. That is the power of the spouse. So why are you selling this? Whatever is in green. Why are you selling? You only sell for your own maintenance. For maintenance. Si kujibamba, chapa sherehe. No. Don't. There's a question like that in 2017. I think 2017 question 5 or question 4. 2017 question 4, question 5, where you're being told that somebody came to you and they told you they want to sell part of the estate because they want to go buy designer perfumes and go to Dubai. That was the wording of the question. Advise them. The answer is they cannot do that. Why? Because section 37 of the Act provides that you can only sell for your own maintenance, not to buy designer things. Okay? Wacha kuharibu pesa ya mwenda zake. So you can only do that for your own maintenance. Okay? So that is the power during the life interest. Now, rule number 3. So we are done with rule number 1. We are done with rule number 2. Rule number 3 is this. Okay? Where the intestate left behind a surviving child or children, no spouse. So remember 36, under Rule 2, 36, there's just a spouse, no children. Rule number 3, under 38, now there are children without the spouse. There are children without the spouse. And this is the one that is mostly set. This one is mostly set, and they set it in terms of the preparation of the schedule of distribution. How will you distribute? They will ask you, how will you distribute? Now, the rule is very simple. Where an intestate has left behind a surviving child or children but no spouse, the net intestate estate, okay, shall, subject to the provisions of section 41 and 42, devolve, okay, devolve upon the surviving child if there be only one, or be equally divided among surviving children. Okay, so where the deceased person left behind children, then everything will go to that child. Everything, guys. If you're one child, 100% of that estate will go to that child. If there are 2 children, 50% each. If there are 3 children, 33.3% each. If there are 4 children, 25% each. Guys, okay, it is everything will be divided equally. And this act, this section does not mention male or female. So every child, male or female, will inherit equally. So if you're given a case where female children are being discriminated, then Rono versus Rono and section 38, which does not mention questions on gender, and then also section 29, which provides that children are dependents, whether they're female or male. So again, that is that. So if you get a question where you're being told the deceased person left behind the following properties, okay, the following properties. They left behind land in Karen, 50 acres in Karen. They left behind 10, somebody tell me, this is the example. They left behind 50 acres in Karen and also 10 apartments in Kilimani. 50 acres in Karen, and then 10 apartments in Kilimani. How do you distribute that? The surviving children are 2. How do you distribute that? Prepare the schedule of distribution. Okay, how do you distribute that? Quickly, someone, so that we can close this point. Nyambura, Zaweria, how do you distribute that? 50 acres in Karen, 10 apartments in Kilimani.
So for the apartment, each child gets 5. For the current land, 25 acres each.
Thank you very much. So that is what you need to understand. So you cannot say that one child gets Karen, the other child gets Kilimani. No. Every property is divided equal. Equal, guys, equal. Okay? There's a question in that in 2018. Question 1. Should be question 1 or question 2. There's a question like that. I will pull it out. Where you're being told this person left behind some Mabati houses, some single rooms. So you divide, you start with the property first. You tell yourself there's 50 acres in Karen, okay? 50 divided by 2. So child 1, 25, child 2, 25. And then you come to the apartments in Karen. Child 1, 5, child 2, 5. So you don't say that, okay, because there's some in Karen and some in Kilimani, one person to take Kilimani. No. Each property divided equally. Money in the bank, 50% each. I hope that is okay. That is clear. Now let us go back to the. So that is the third rule. That is the third rule. Okay. And then now we have the fourth rule. The fourth rule is this one under section 39, where the deceased person died a bachelor without a child. The deceased person died a bachelor without a child. No surviving spouse, no child. If the question tells you this person died with no child and no spouse, then everything will go to the parents. Okay, the mother and the father equally, the mother and the father equally, and if the mother and the father is not there, the brothers and the sisters equally. If the brothers and sisters are not there, half brothers and half sisters equally. If they're not there, all other relatives equally, up to the 6th degree of consanguinity. If there is none, then we have the principle of honor, vacancia. The principle of escheat, bona vacancia, which means that estate shall go back to the government. It will go back to the government, and serikali itaichukua through the Financial Assets Recovery Authority, the Unclaimed Financial Assets Recovery Authority. So this act has been amended. This part has been amended. It's not that the AG takes some time to do these things, but we now have an AG, so we expect that she will do some things quickly. So these two have been amended because the former position was everything else, if you don't have a spouse and a wife, everything else will go to the father. And it will only go to the mother if the father is dead. So this has been removed because it is discriminatory against the mother, and therefore the two of them will enjoy equally. Everything else that was remaining will go to the two of them equally, the father and the mother equally. And if they're not there, it will go to the brothers and sisters equally. If they're not there, half brothers. So that is what happens. So that is under Rule 4. Rule 4 is where no spouse, no child. Everything else goes to the parents. If the parents are not there, brothers and sisters. If they're not there, half brothers and half sisters. So relatives will only enjoy if half brothers are not there. Half brothers will only enjoy if brothers and sisters are not there. And brothers and sisters will only enjoy if the mother and the father are not there. And if they're not there, all of them, then the estate will go to the government through the doctrine of escheat, bona vacancia. All right, so that is the fourth rule. That is the fourth rule. What is the fifth rule? The fifth rule is where the deceased person was polygamous. This is the fifth and the final. There are only 5 rules. The fifth and the final rule is the deceased person was polygamous. Okay, the deceased person could not control himself, could not control the urge of having many wives. Okay, having very, very many wives. So the deceased person was a man from Luo Nyanza, polygamous. Okay, so in that instance, what do we do? What is the rule? What is the law saying in as far as the rule is concerned? Okay, very simple. Okay, where an estate has married, an intestate has married more than once under any system of law permitting polygamy, his personal and household effects, again, the same thing, the personal and household effects in the first instance shall be divided among the houses. Okay, shall be divided among the houses according to the number of children in each house, but also adding the wife, any wife surviving him as any additional units to the number of children. And then number 2 is the distribution of the personal and household effects and the residue of the net intestate estate within each house shall be in accordance with the rules set out under section 35 to 38. What does that mean? It simply means that if you're going to distribute the personal and household effects, we have 3 houses, house number 1, house number 2, house number 3. So all the personal and household effects in house number A will remain there. Whatever was in house number B will remain there. Whatever is in house number C will remain there in terms of personal and household effects. So if there's a curtain there, the deceased person died and left his phone in house number A, itabakia hapo. Kama aliacha suti zake zote house number B, zitabakia hapo. Kama aliacha all the jewelries in house number C, zitabakia hapo. Okay, so the personal and household effects will remain in each house that they belong to. And then the children will be regarded as units. The children will be regarded as units, and the wives, the surviving wives or spouses, no, wives only. Wives only. You cannot have a woman that is married to more than one man unless she's a lady from Nairobi and she's a lawyer. Ogopa mawakili. Moto fire. So unless she's a lawyer and a wakili in Nairobi, you can debate that. But on ordinary circumstances, no woman should be married to two men. Okay. and only Nairobi can defy that rule. That is a rule of nature. Can only be defied ukifika Kanairo, shamba la mawe indeed. So the rule is very simple. So the children will be considered as units, okay, plus the surviving wives as additional units. So that if house number 1, there are 2 children. House number 2, there are 3 children. House number 3, there are 4 children. Then we are going to have house number 1, 2 plus 1, that is 3 units. House number 2, 3 plus 1, 4 units. House number 3, 4 plus 1, 4 units. And then that is 3 plus 4, 7, 7 plus 4 will give us 11. So the entire estate is going to be distributed equally among the 11 units. So each house will get according to the number of units that they have. So the more number of units you have, the more you get. So any house that doesn't have a wife, if house number 1 did not have any surviving spouse, then house number 1 will only have the 2 units. Okay? If house number 2 doesn't have, so you get what I'm saying? You get what I'm saying? So the more number of units you have, the more things you get. Okay, that is that. And then lastly, before I open the floor for question, I hope you're noting down your questions if you have any, is the doctrine of hodgepodge. That is under section 42. But before I go to hodgepodge, let's talk about 41. Okay, now 41 is very simple. It simply says that anything that is supposed to devolve to a child must be given to a trustee. It will be held for them in trust. Anything that is devolving to a child must be held for them in trust until they get to the age of 18. That is what trust principle under section 41 provides. Trust principle under section 41 provides. And then lastly is the question of the doctrine of hodgepodge. Hodgepodge, not hotpot. Jua Waluya sahii wanasema hii ni hotpot gani tujaisikia. Si hotpot. Let me type hapo. Hodgepodge. Okay. Anyango Kagere. What are you saying? That is hodgepodge. Hodgepodge. Okay. Hodgepodge. So hodgepodge simply means that that where an intestate during his lifetime or by will paid, given, or settled any property to or for the benefit of a child, grandchild, or a house, or the property had been appointed or awarded to any child or grandchild under the provisions of section 26 or 35, that property shall be taken into account in determining the share of the net intestate estate finally accruing to the child, grandchild, or house. Tunasema tu, kama kuna kitu ulishapewa, kama babako bado alikuwa hai, hautapewa sawa na wenzako, wachia wenzako pia waenjoy. Okay? So kama babako alikuwa amekupea shamba na hakuwa amepea watu wengine, kama shamba ilikuwa 10 acres na wewe ulipewa yako 5, hii 5 imebaki, you can't get equal with other children or other beneficiaries. Okay? Kama in the houses, if it is polygamy in the houses, kama the deceased person favored house number 1, okay, the deceased person favored house number 1 by leaving behind 10 acres of land to house number 1. When you're going to distribute the estate, we cannot distribute it equally to house number 1 as well. Okay, the rest will have to benefit first. We'll have to consider that as we distribute. We'll have to consider that as we distribute. So that is what you're calling the doctrine of hodgepodge. So that the previous benefits must be brought into account. Kama babako, you are the favorite of your father, and your father, before he died, he gave you a piece of land, he transferred a large sum of money to your account, he paid for your expenses, he gave you his shares in a company. When we are distributing according to the rules of intestacy, trust me, you'll not get equal with everyone, okay? Because we are considering what you had been given in a will or any gift in contemplation of death or a gift inter vivo. That is the rule when it comes to the doctrine of hodgepodge. So guys, we have discussed all the rules of intestacy. So anytime you see a question that Mr. James died intestate, masikio unayafungua, unakuja section 35, unajiuliza, ni je, aliwacha bibi na mtoto? Kama ndio, unaingia section 35 na una distribute the estate according to the rules in 35. Okay? Alafu unajiuliza tena, je, alikuwa na bibi peke yake bila mtoto? 36. Unajiuliza tena, je, alikuwa na watoto peke yao bila bibi? 38. 39. Hakuwa na bibi wala mtoto. 40. Alikuwa polygamous. Okay? For those who don't understand Kiswahili, I've just said you look at all the instances from 35 to section 40, which says, number 1, did the deceased person leave behind a spouse only? Let me go there. A spouse only, one spouse and surviving children or child, that is 35. And we have discussed how the estate will devolve. You go to the second one. Did the deceased person leave behind just a spouse only, no child? 36. You go to the third rule in 38, where only children were left behind. That is 38, equal distribution. 39, where no child or spouse was left. Everything goes to the mother and the father. And then 40 is where polygamy is. And guys, that is the rule of intestacy. That is the law applicable to intestacy. Maswali kwa wingi, alafu tunafungia. Najua kuna wengine hapa wako na kiu. Wanataka kwenda kuonja. Wasikii vizuri kama wajaonja, wako na kiu. Tayari nishawaambia siku moja utaenda hiyo quiver unataka kwenda saa hii. Utaamka next year. Kama by exam ilifanyiwa, ukiangalia status watu wanakuwa admitted. Wewe ndo unaamka from quiver. Enda tu. So, maswali kwa wingi, so that we are all on the same page, because I want you to understand. Do you understand what I've said? Let's start with Abdisalan Gure.
Yeah, Mwalimu, I had one problem, Bani. For example, if you go to the Matrimonial Properties Act, it defines the matrimonial home as being jointly owned by the spouses. So in the event that the mzee dies, that matrimonial home should be a joint property between, it will devolve to the living mother. So is it going to be part of, can she apportion that part only belonging to the, I mean, now that it's her own property, she has a right to dispose of, I believe. So what does the law say about that?
Matrimonial property is not a free property. A matrimonial, not a matrimonial property. A matrimonial, there's nothing.
A matrimonial home. A matrimonial home.
Yes.
A matrimonial home is a joint property. So if in the event of the death of the father, then it devolves to the mother, isn't it?
Okay.
So it does not form part of the net intestate estate. That's what I wanted to come out clearly.
Yes, it does not form part of the net intestate estate. Hiyo ni mali ya bibi na atauza kama nataka. Hiyo ni yake. Atafanya kitu nataka. It will not form part of intestacy, neither will it form part of the will. It is not a free property. It is not part of the estate.
Thank you very much. Thank you, Mwalimu.
Karibu sana. Karibu sana. Maswali? Nzwali? Njao Zandra.
Yes, Mwalimu, I have two questions. The first one is where the spouse is selling property that is necessary for his or her own maintenance. Do they have to prove that it is indeed for their own maintenance? And if so, are they proving to those who they are seeking the consent of?
Yes, you cannot just sell. First, remember, you have to apply for, if it is land, you have to apply for consent from the court. You have to apply for leave from court so that the court can allow you to sell. So in applying, you have to indicate and tell the court that, hey, I am selling because I am dying of njaa inanimaliza. So wacha niuze. So the court, you have to show that it is for maintenance. Why are you selling? So you have to show why you are selling. That is a must. You cannot just wake up and say, I want to sell. Why? You can only sell for maintenance. If there's no reason for selling, you can't sell. Chonjo?
Yes, thank you. Another one is where we are talking of previous benefits being brought into account. Are we looking at the value of what maybe one child was given and another was gifted? For example, if there were two kids and in the process or in the lifetime of their dad, he had gifted them like each a car, will we look at the value of the car, or we just consider that they were given cars?
If the value is relevant, if you're given a car worth 10 million and one was given a car worth hiyo probox ya Wakikuyu, ya Waru ya 50,000, that is relevant. But ukipewa gari ya 1 million, mingine 2 million, that is not important. So the value is important if it is so big that it's going to be unfair. Okay? So it depends on the value. It depends on what you received as a gift. If you received something more, if you received 10 acres, all of you could be given land, but if one was given just a quarter of an acre, mwingine akapewa 100 acres of land. Si unaona hapo kuna ka disparity.
Yes.
Swali nyingine ama nyingine. Mimi naona hamna maswali. So if you don't have questions, guys, I will let you guys go and have a very lovely weekend. It is my wish to you that you enjoy your weekend to the fullest without any discombulations or disturbance of the head. So please go and enjoy the weekend and remember to read and remember that these things are not complicated. They're very simple things. If you don't understand them now, it is not late to understand. You will understand them. Just revise pole, angalia maswali zingine, uliza maswali more and more, na utakuwa sawa. Otherwise, guys, have a lovely evening. I will stop the recording. The recording has been stopped. To John,